Did prosecutors botch the Rittenhouse case? Throughout the past year, the Kyle Rittenhouse case has taken center stage in the national debate of race relations, self-defense laws, and the Black Lives Matter movement. The entire case has served as a microcosm of the many issues which America faces today, and has divided people into two distinct camps, one in which they believe he is innocent, and one in which they believe he is guilty. However, with his recent acquittal, it is important to understand the background of the case. Kyle Rittenhouse was a 17-year-old out-of-state male patrolling the streets of Kenosha, Wisconsin on August 17, 2020, when, in purported self-defense, killed two men and injured one with his AR-15. He was arrested that night, and on November 19, 2021, a year after the deadly shootings, he was acquitted on all charges, walking out of the courtroom as a free man. Yet now that his trial is over, many people have quickly sought to assign blame and responsibility for his acquittal. To me, there is one party to assign responsibility to in particular: the prosecution. The prosecutors botched the Rittenhouse case through unprovable charges and displeasing the judge. However, they are not fully at fault for the verdict of the case, as there were unfavorable aspects of the case that were out of their control. To begin, the prosecutors botched the Rittenhouse case, as they levied harsh and unprovable charges against Rittenhouse, which made it almost impossible to charge him. First, the prosecution charged him with first-degree reckless homicide, first-degree intentional homicide, and attempted first-degree intentional homicide, along with a host of minor unrelated charges. These charges are among the harshest and hardest to prove in the United States, requiring large amounts of evidence according to Cornell law. Charges of the first degree often require some sort of premeditation, which requires that the defendant acted with foreknowledge and planning of his murder, something which the prosecution simply could not prove. Along with that, the nature of the case made it possible for the defense to trump these charges with a simple claim of self-defense, which required less evidence to prove than the murder charges.